Good morning.
So I have a bailiff, if I'm not mistaken, correct? Who's my bailiff?
Correct. Piper Johnson. Thank you.
Good morning, Mr.
Good morning.
Johnson. All right, we have for my bailiff, are we good to go now that we're all here, now that we've been transferred to our rooms?
Yes, we are good to go. Thank you.
All right, so let's call the case of Marks versus Sunny's Rooftop Bar. My name is Judge Raina McDonald. I'm scoring judges. Please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and me. Can the attorneys please make appearances?
Hi, my name is Luke McLaughlin, and I am representing F.O. Marks, the plaintiff in this case, and I am here along with my co-counsel, Kate.
Thank you.
Good morning, Your Honor. My name is Jasmine Garcia, and along with my co-counsel, Miss Emily Perez.
Good morning, Your Honor.
Good morning.
We represent the defense, Sunny's Rooftop Bar.
Okay, thank you. We will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is on the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking.
Your Honor, if you don't mind, defense has some pretrial matters before we begin opening statements.
Please go ahead.
Yes, Your Honor. Your Honor, first we'd like to invoke Rule 615, which calls for the constructive sequestration of all witnesses barring party representatives.
Okay, that's granted.
Your Honor, the defense's party representative today is Miss Sunny Mehta.
Thank you.
Your Honor, we'd also like to ask about your preferences of screen sharing for exhibits and demonstratives. Would you like us to ask permission before every time we screen share?
No, that won't be necessary. Please go ahead and screen share as you need them in your presentation.
Yes, Your Honor. With that, the defense is ready to proceed.
Are there any preliminary issues from the plaintiffs?
No, Your Honor.
Okay, then let's go ahead with opening statements.
May it please the court. He saw her. She saw her. She could have saved her, but instead she just kept serving her. Your Honor, counsel, members of the jury, she is Sunny Mehta, owner of Sunny's Rooftop Bar, and the one who served Jessica Marks and her best friend, Morgan Levin, on the night of March 24th, 2019. Now, you will hear from Ms. Levin today that Jessica Marks was obviously intoxicated at Sunny's Rooftop Bar. Early on, you will hear that Jessica's eyes were bloodshot. She smelled of alcohol. She was acting really loud, and she was slurring her words. And you will hear that despite this, Sunny's Rooftop Bar continued to serve her alcohol. You will hear that later on, Jessica Marks stumbled into Sunny Mehta, the owner of the bar. And after this, did Mr. Mehta call her a cab? Did he cut her off? No. You will hear that he cracked a joke and he continued to serve her alcohol. He saw her. He could have saved her, but instead he just kept serving her. And you will hear from Ms. Levin that after Jessica Marks finished drinking, she got in her car and she drove off. And almost immediately, after getting onto the straight, well-lit road right outside of Sunny's Rooftop Bar, Jessica Marks crashed. And she did not survive that crash. Now, after her death, an autopsy was taken. This autopsy found that Jessica Marks drank so much alcohol at Sunny's Rooftop Bar that her blood alcohol content was 16 times the legal limit. The evidence will show that the continuous serving of alcohol at Sonny's rooftop bar to Jessica Marks, while she was obviously intoxicated, is what killed her. Now, why would Sonny's rooftop bar be liable for this tragedy? Well, members of the jury, I ask you to look no further than the California Business Provisions Code, section 25602.1. This states that any bar, such as Sonny's rooftop bar, that continuously furnishes alcohol to an obviously intoxicated minor, like Jessica Marks, is liable for any harm that comes to that minor due to the furnishing of alcohol. Now, in order to find Sonny's rooftop bar liable under this code, I have to prove to you 4 things today by a preponderance of the evidence. And all that means is slightly more likely true than untrue. Now, the first 2 things, that being that Jessica is under 21 and that Sonny's rooftop bar was licensed to sell alcohol, are already stipulated or agreed upon, meaning I don't have to prove them to you today. The third, that the alcohol served to Miss Marks by Sonny's rooftop bar was a substantial factor in causing her death, is supported by the autopsy I just showed you. Once again, her blood alcohol content was 16 times the legal limit. And that leaves the fourth. The key issue in this case was Jessica Marks served alcohol by Sonny's rooftop bar while she was obviously intoxicated. Members of the jury, you will hear testimony today. You will be presented with evidence today. The answer will become clear. Yes, she was. Now, ladies and gentlemen of the jury, remember this. She saw her. She could have saved her, but instead she just kept serving her. Thank you.
Thank you. Counsel? Whenever you're ready.
Your Honor, opposing counsel, members of the jury, may it please the court. She chose before she drove. The plaintiff just came up here and told you the tragic story of Jessica Marks. While we don't disagree with how this story ends, it's important to know how the night of March 24th, 2019 really began. Because it doesn't actually start at Sonny's rooftop bar. It starts at a Brentwood Airbnb where Jessica Marks chose to drink before she drove. The plaintiff just tried to tell you that the defendant was responsible, but members of the jury, what they didn't tell you were the choices that Jessica Marks made before her death. You see, at 8 p.m. that night, Jessica Marks decided that she was going to drive to a bar, that she was going to drink at that bar, and drive again. At every point that night, before she left her Airbnb, while she was drinking, and as she was leaving the bar, Miss Marks intended to drive after drinking. We agree that this is a tragedy, and our hearts go out to Miss Ethel Marks for what has happened. The question today is not, should this have happened? It shouldn't have. The question is, who is responsible? Today, the plaintiff brought this case before you, and as such, they bear the burden of proof. They must prove to you, by preponderance of the evidence, meaning more likely than not, that Sonny's rooftop bar actually saw and knew that Miss Marks was obviously intoxicated while they served her. But they won't be able to prove their case today, members of the jury, because today we've brought before you an affirmative defense. This is our first affirmative defense based on comparative negligence. What this means is that it wasn't actually the bar's fault, but Jessica Marks' own negligence that resulted in her death. And today we bear that burden, and we will prove it to you by preponderance of the evidence. Because twice, Jessica Marks chose to drink before she drove. Today you'll hear that the first time Miss Marks chose to drink before she drove was at her Airbnb. You'll hear that Miss Marks drank wine and then decided to get in a car with her best friend in the passenger seat, Miss Marks, took lives into her hands. And then you'll hear that again, for a second time that night, Jessica Marks made a decision that she chose to drink and drive again. You'll hear that after getting to that bar that she drank, that she ordered, members of the jury, nobody forced her to order her drinks, and certainly nobody forced her to drink them. You'll hear that even at the end of the night, Miss Marks had the option of taking an Uber home, that her best friend begged her to take that Uber, but Miss Marks said, "No, I'll drive." Jessica Marks chose before she drove. When tragedies like this happen, it's natural to look for someone to blame. And it's hard for a mother to blame her daughter, but members of the jury, it's your job today to decide who is at fault. So at the end of today's trial, I'll come back up here and ask you to find Sunny's Rooftop Bar not liable for the death of Jessica Marks. Thank you.
Thank you both. All right, I think for the jurors, we have the chance to score our ballots after the opening statements, but we need to do the rest of it after the, so I'm taking a second to look for our ballot. There we go. All right, so we can return now to the proceedings. We will now hear before the plaintiff calls its first witness, I'll ask everyone to switch to gallery view. That button is in the upper right of your screen. This will allow you to see the attorneys and witnesses at the same time. So, assuming we've all done that. If the plaintiff is ready to proceed, then you can call your first witness.
Your Honor, prior to calling our first witness and pursuant to the Federal Rule of Evidence 804 and Federal Rule of Civil Procedure 32, the plaintiff at this time moves into evidence excerpts from the deposition of Stevie Rager. Counsel, I am seeking to introduce page 2, lines 9 through 23, page 4, lines 4 through 14, as well as lines 20 through 21, page 5, line 23, page 6, lines 1 through 14, and also lines 19 through 21. Please let me know if you need me to repeat any of those. Okay. If it is acceptable to the court, I have the excerpts in transcript form. May I constructively publish this to the jury, barring any objections?
Is there any objection from the defense?
Yes, Your Honor. While we have no objection to hearsay due pursuant to stipulations, Your Honor, we actually would like to take a look not only at those excerpts that they plan to enter for other evidentiary objections. We believe that there's a number of them in that document, and we'd also ask, Your Honor, that opposing counsel actually enter this during their direct examination time.
You may have the time to look at them now and see if you want to raise any objections. So let's take that first in order, and I'll give you a few minutes to do that.
Yes, Your Honor.
So that would be, we're looking to enter lines 9 through 23 on this page.
No objection to this page, Your Honor.
Okay.
We are looking to enter from this page lines 4 through 14. as well as lines 20 and 21.
No objection to this page, Your Honor.
Okay,
And then on page 4, we have, that was page 4. On this page, we just have line 23. It's just the question, the answer will be provided on the next page.
Okay, no objection.
And then on this next page, we have are looking to enter lines 1 through 14, as well as lines 19 through 21.
Yes, Your Honor. An objection first to the answer on line 4 of this page, Your Honor, that's speculation.
May I respond, Your Honor?
yes, you may.
I believe that the specific part of this answer that opposing counsel is taking issue with is the part that says, as if to say, get a load with that girl. I don't see any potential speculation.
Your Honor, if I may.
Go ahead.
Your Honor, the declarant in this deposition, Stevie Rager, has no personal knowledge of what Sunny Meadow was thinking when they made eye contact. And for that reason, that witness cannot step into the mindset. And it is speculatory for them to say this quote, get a load of that girl. They have no idea what Miss Meadow was thinking.
So is counsel for the plaintiff right that the issue you're taking with this is with the sentence, as if to say, get a load of that girl?
Yes, Your Honor.
And the rest of the answer is not objectionable from your perspective?
The rest of the answer is not objectionable, Your Honor.
I will sustain the objection to the extent for that one sentence. I think that is speculation. The rest of it is not speculation, and the rest of the answer can be admitted.
Yes, Your Honor. Opposing counsel, Your Honor, if opposing counsel wouldn't mind, would they please restate what other portions from this page they are trying to enter into evidence?
Sure, it is lines 1 through 14, and then 19 through 21.
No objection to the rest of this page, Your Honor.
And that is all we are looking to enter.
Okay, so Counsel Garcia, you objected to the, you asked about having them enter at the time of during his direct examination. Would you like to be heard on that point?
Yes, Your Honor. We think it's only proper for this exhibit to be entered and these excerpts to be entered only during the direct examination, as for each examination there's an allotted time, and we ask that opposing counsel don't go out of that time, Your Honor.
Mr. McLaughlin, would you like to respond?
Your Honor, we only plan on entering this transcript, not any testimony to go alongside it. We recognize that this has to be entered in our case in chief, but specifically regarding direct examination, this witness has been stipulated to be unavailable. They can't be here today, so there will be no examination of this witness.
Your Honor, if I may be heard.
Go ahead.
We certainly think that testimony is possible. We'd ask that if they want to enter what's written here in this exhibit, that they ask their witness to read it out loud during their examination.
Okay, my ruling is going to be that because this witness is unavailable, I'm going to allow it to be entered at this time. And Attorney Garcia, I think you have benefited from the time issue as well by being able to review this and not you have to do these review during your time in cross. And I think this is a cleaner, neater way to do it. So I'm going to allow the exhibits to be entered at this time.
Yes,
Subject to the restriction of the sustain with regard to line 7 on page 6.
Your Honor, if I may also be heard once more.
Not post ruling. If it's a different issue, go ahead. But if it's about this, I'm done my ruling.
Yes, Your Honor, we understand that. We'd actually like to ask that we enter another part of this exhibit from the same deposition into evidence on behalf of the defense.
Your Honor,
I think you can bring that up at the beginning of your case when it's your turn to start. Either your cross, if you want to do it before cross, or if you want to do it before the beginning of your case. But I'm not going to do it right now.
Yes, Your Honor.
Okay. Go ahead, counsel for the plaintiff, Mr. McLaughlin.
the plaintiff calls Morgan Levin to the stand.
Okay. Good morning.
Good
Ms. Levin.
morning.
May I inquire?
Yes, please.
Good morning, ma'am. Could you please state your name for the record?
Yeah, sure. Good morning. I'm Morgan Levin, Levin.
And how did you know Jessica Marks?
Jessie is what I called her. She was my best friend. We met in middle school right when I moved down to Dale Cove from Carolina, and we were just best friends all throughout high school, and we stayed friends in college.
Did she ever visit you while you were in college?
Yeah, she did. She came to LA, that's where I go to college, plenty of times, but we're here today because of the last time that she came in March of 2019.
And what was the plan for this trip in March 2019?
Well, we were just gonna spend all the time we could together. It was hard being apart in different states for school, so we were just hanging out, going out every night, watching movies together, catching up.
How old were you at the time?
We were both 19.
I want to now focus on the events of March 24th, 2019. Did you do anything when you first saw Jessica that day?
Yeah, so Jessie, she picked me up from her Airbnb to take me to her Airbnb, which was right next to my dorm. She picked me up, we chatted, just visited with each other, and had a glass of wine.
Then what did you do?
Well, then Jessie said that she wanted to go out, and I knew of this bar, Sunny's rooftop bar, and I decided that's where we should go. It's in Malibu, so Jessie drove us there.
And who served you at this bar?
Well, there were two servers there that evening. I know their full names now, Sunny Meta and Frankfurt Johnson. And Sunny owned the place and she was serving us, and Frankfurt was a bartender.
And early in the night, did Jessica ever begin to show any symptoms of intoxication?
Yeah,
Objection, Your Honor, if I may be heard on a lack of personal knowledge.
Go ahead.
The opposing counsel has just asked if Jessica Marks showed any symptoms. We certainly agree that the witness is able to testify to any symptoms that they saw Miss Marks apparently showing, but they can't ask specifically if she did show any symptoms because they can't know exactly for sure beyond their reasonable observations.
Mr. McLaughlin.
If opposing counsel prefers, I could rephrase the question to be, did you see Jessica show any symptoms? I'm not sure how big of a change that is, but if that's what you are requesting, then I will happily make that change.
I think that's a good idea. Go ahead. I'll sustain the objection. And you
Yes,
can-
Your Honor.
Miss Levin, early in the night, did you ever see Jessica show any symptoms of intoxication?
yeah. So like I said, she was the one who drove us to the bar. And about right when we pulled in, that's when I noticed she was a little tipsy. Her driving was fine on the way there, but we got inside and I definitely noticed she had flushed cheeks and red eyes, and she was being real goofy, not making much sense. I wouldn't say she was drunk yet, but I know that she was tipsy.
And I'm now showing you what has been pre-marked for identification as exhibits 11 through 16. Do you recognize these photographs?
Yeah, I do. I actually took them.
Do these photographs fairly and accurately depict the scene as it appeared that day and that time?
Yeah, I remember everything about that night, and that's what it looks like.
Were they changed or altered in any way?
Not that I can see.
At this time, the plaintiff offers what has been pre-marked as exhibits 11 through 16 into evidence as exhibits 11 through 16.
Objections from counsel?
Without objection, Your Honor.
Then they'll be entered exhibits 11 through 16.
May I constructively publish this to the jury?
Yes, you may.
Now, Ms. Levin, could you tell the jury which of the drinks present in these photographs were drank by Jessica Marks?
Yeah, so you've seen that first picture right there, 11. She's holding a glass of wine, and I was pouring one for myself. And I only had one glass out of that bottle. So Jessie, she had the rest of that wine. Then in the second picture, we ate some chips and guac. The third one, sorry, she has a White Claw and a beer can, and she drank those. And then the next one, she has another beer can, and that brown drink with the straw, that was a Jack and Coke.
Objection, Your Honor, to lack of personal knowledge, if I may be heard.
Go ahead.
Objection to the witness knowing that that drink was a Jack and Coke. First of all, the foundation hasn't been laid that she knows exactly what that drink is, what's in that clear cup, and we believe that that's a lack of personal knowledge matter.
Mr. McLaughlin.
Your Honor, Ms. Levin has testified that she was with Ms. Marks that evening, so she would have been there while these drinks were being ordered. So she would know the drinks that were being delivered.
Your Honor, if I may.
Go ahead.
We actually have it on a good faith basis that Miss Levin wasn't actually with Miss Marks when that particular drink was ordered, Your Honor. Therefore, we think that it was a lack of personal knowledge that she knows that is a Jack and Coke, particularly alcohol.
I'm going to let you take that up on cross. I think the fact that they were together during the evening, if you have a gap, why don't you take that up on cross? I'm going to overrule the objection.
Yes, Your Honor.
Thank you, Your Honor. Ms. Levin, could you go back to listing the drinks of these that were drank by Jessica Marks specifically?
Yeah, so I think I was at the fourth picture. You can see 2 White Claws. So she had another White Claw on top of the one you saw in the first picture. And I think that's all of them. So that makes 3 White Claws, a Jack and Coke, a bottle of wine, and a beer.
And did she drink anything that wasn't depicted in these photos?
Yeah, to finish out the night, we had a round of shots, green tea shots. They were on special, I guess.
So in total, how many drinks did you see served to Miss Marks?
That makes 7.
And was she served all these drinks at once, or was it more progressive throughout the night?
Yeah, it was more progressive. So I'd say that they would come and they'd serve her, or I guess our table. They'd check in and ask us what we wanted to drink every 15, 30 minutes or so.
Was there ever a time where Jessica left that table?
Yeah, there was. So around 10, we went downstairs just to use the bathroom. Where we were sitting was up on the rooftop, so we had to go inside.
Did anything of any significance happen while you were going to the bathroom?
Yeah, well, Jessie at this point, she was showing some real signs. I mean, she was slurring and stumbling and wasn't making any sense at all, and her eyes were just bloodshot. And when she was going down those stairs, she almost took a nosedive. I mean, I was scared that she was gonna like break an ankle or something. And she caught herself on like Sonny Meta's shoulder, and Sonny looked at her and said, maybe we should cut this one off. And she just sort of laughed at it.
What was his tone when he said this?
Well, she said she was just laughing about it. It was joking.
And did she cut Jessica off after this stumble?
No, she kept serving her and kept serving her.
I'm now showing you a video file that has been pre-marked for identification purposes as Exhibit 10. Did you review this before trial?
Yeah, I saw it in my depot and it's still in my phone. It's the last video I have of Jessica, so I've watched it since then too.
Were you the one who recorded this video?
Yeah, I was. She was acting all goofy and I took it. Yeah, I'm the one who took it.
Does the video fairly and accurately depict the scene as it was recorded?
Yeah, it does. It looks like that at least.
Are there any material alterations or deletions to the video?
Not that I can tell.
At this time, the plaintiff offers what has been pre-marked for identification as Exhibit 10 into evidence as Exhibit 10.
Any objections, Ms. Garcia?
Without objection, Your Honor.
And then it's so entered.
May I publish it to the jury?
Yes, go ahead.
Your Honor, if I may, I guess, ask for a pause in any timing occurring right now as this video buffers. This is not really something in my control.
Do we have a timekeeper who's keeping record?
I'm sorry, Your Honor, could you repeat that?
Do we have a timekeeper who's keeping the time record?
I believe so.
Okay, so I can ask the timekeeper to give us a pause of approximately how long it takes for this to load.
Thank you, Your Honor.
Question is it going to load?
Your Honor, since this appears that this is not going to load, may I just constructively publish this to the jury?
Sure. Yes, since it was without objection, go ahead.
Thank you, Your Honor.
I can do it if you want. I'm sorry, I'm the D's second chair. Would you like me to share the video for you?
Oh, yeah, if you could, that would be great. Thank you.
And for the timekeeper, when the video starts to play is when you should resume timekeeping.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy, Mom and Dad. Inspired me. Okay, well, go big or go home.
Thank you. Now, Miss Levin.
Yeah.
You, based on what you saw, was Miss Mark showing any signs of intoxication while you were filming this video?
Yeah, I mean, she didn't really have great like coordination when she pulled her glasses down, and she was slurring. She looked confused. I mean, she didn't know what to pick up at the end. She was being real loud. That's how Jessie looks when she's drunk.
Was she served any more drinks after this was recorded?
Yeah, that was posted at 11, 10 minutes after 11 maybe, and we didn't leave till nearly midnight. So we had another hour of drinking after that.
And when you left, did anyone say anything to you or Miss Marks?
Jessie just walked right past Sunny Meta and Frankfurt, and I think they exchanged good nights, but nobody stopped her. Nobody tried to save her.
And Miss Levin, I have to ask you, when throughout the night was Miss Marks showing symptoms of intoxication?
Well, we got to the bar and she was already tipsy, and it just got worse and worse throughout the night. And by the end of the night, she was real drunk.
And how often would you say?
Excuse me, I saw a notice from the timekeeper that the plaintiff's time has expired. So we're going to stop the examination at this point.
All right, thank you, Your
And
Honor.
we're going to let defense move into cross-examination.
Yes, Your Honor. Good morning, Miss Levin. First of all, I'd like to say I'm very sorry for your loss. We'll get you out of here as quick as possible.
Thanks, and good morning to you too, ma'am.
Ma'am, you were with Jessica Marks on the night of March 24th, 2019, right?
Yeah, I was. We were hanging out that day.
You told us just a bit earlier that you actually met at her Brentwood Airbnb,
Yeah, she picked me up and took me there.
and you told us that while you were there, you and Miss Marks had some drinks, right?
I had one drink and Jesse had one or two.
That's right. Miss Marks had 1 or 2 drinks of wine, right?
Yeah,
Let the record reflect that we're now putting up a timeline. And on that timeline, we're going to put drinks wine at Brentwood Airbnb. Miss Levin, after you and Miss Marks drank at that Airbnb, you've decided to go to a bar, right?
yeah, Sonny's rooftop.
That's right. And that bar, that's in Malibu, correct?
Yeah, it's kind of a hike, but my friends suggested it because they didn't ID.
Well, Miss Levin, it's kind of a hike, and that's a 25-minute drive at least, right?
Yeah, you know, LA traffic, it can get real bad. So 25 to 40, depending on the time of day.
And Miss Levin, that 25 to 40-minute drive, well, Miss Marks drove you there, didn't she?
Yeah, she did.
And she drove you there after she just drank some wine?
Your Honor, I'm going to object to relevance.
Your Honor, if I may.
Go ahead.
Your Honor, our burden today as defense, as we brought a first affirmative defense, is comparative negligence on the negligence of Jessica Marks. The fact that Miss Marks decided after drinking wine at her Airbnb to drive all the way from Brentwood to Malibu in a car after drinking alcohol is certainly relevant to the negligence on her behalf.
Mr. McLaughlin, would you like to respond?
Well, I would then like to add an objection of improper character evidence. The drive in question in trial today was what she made after going to Sonny's rooftop bar. If this is being offered to show negligence, that's being offered to show a character trait on behalf of Miss Marks in order to prove that she acted in accordance with that trait at Sonny's rooftop bar. So I would argue improper character evidence.
Before I ask Ms. Garcia to respond to the improper character evidence, are you withdrawing your objection with regard to relevance?
Not necessarily, Your Honor. I would still say that we are talking about the night after, the drive after she drove to Sonny's rooftop bar. So a drive before, I would still argue, is not relevant to this case.
All right, I'm going to overrule the objection on relevance, but would you please respond to the objection with regard to character evidence, Ms. Garcia?
Of course, Your Honor. Your Honor, character evidence is something that's acting in conformity therewith propensity purposes. Your Honor, we're not using this for propensity purposes, as the drive before getting to that bar, not just a mere 30 minutes before arriving at that bar, is certainly part of today's case and part of Jessica Marks's negligence. We're saying that it was her decision to drink and then drive, and then drink and drive. Your Honor, we're not using this to prove that she did it in conformity therewith, but to prove that she did it at all. Your Honor, for her to drive to that bar in her own car with an intention to drive back after drinking, Your Honor, that's negligence.
I'm going to overrule the objection and allow the testimony.
Thank you,
Please
Your Honor.
continue.
Yes, Your Honor. Miss Levin, after drinking wine at her Airbnb, Miss Marks drove to the bar, didn't she?
Yeah, she seemed fine. I even felt fine going with her, and I'm pretty cautious about that stuff.
Well, Miss Levin, I'm sorry. My question wasn't to did she seem fine. I asked you if she drank alcohol and then drove.
Right, sorry, I've never been to court before. So yeah, the answer is yes, ma'am.
Let the record reflect that we're now stating Jessica drives to Malibu 25 minutes away on the timeline. Now, Miss Marks, after she drove you to Malibu, well, then you guys both arrived at the bar, didn't you?
Right, we got to Sonny's.
You got there at around 9 p.m.?
Yeah, I think that's right.
And when you got there, Jessica, well, she parked her car in the parking lot.
Yeah,
You both walked into the bar.
right.
Let the record reflect that we're putting arrived at the bar at 9 o'clock on the timeline. And Miss Levin, after arriving at the bar, you ordered alcoholic drinks, didn't you?
Yeah, Sonny Meta gave them to us.
That's a yes to my question. You and Miss Marks ordered alcoholic drinks.
Yeah,
And, well, Miss Marks, she ordered her own drinks, didn't she?
yeah, we were both just ordered whatever we wanted. It was my treat. I was just so excited that Jesse was in town.
Let the record reflect that we're now putting drinks at the bar on the timeline. Miss Levin, after that, you guys spent 3 hours at that bar, didn't you?
Yeah, we were there until 11:45.
And ma'am, at the end of the night, you both left at around 11:45 and you took an Uber, didn't you?
Yeah, Jesse was drunk.
Well, ma'am, you took an Uber and you offered that Uber to Miss Marks, right?
Yeah, I begged her to come with me. I didn't think she should be driving after all that she'd been served.
That's right. Miss Levin, you begged her to come with you, but Miss Marks didn't get in the Uber, did she?
No, she got in her car.
That's right. You let the record reflect that we're now putting refuses in Uber from Morgan Levin on the timeline. You just told us that she got in her car. That means, Miss Levin, that you saw her walk away and get into the driver's seat. Right?
Yeah, I did.
Miss Marks drove away after not getting in an Uber?
What? Sorry, could you repeat that?
After refusing your Uber, Miss Marks drove away. Right?
Yeah, I wish I could go back and have stopped her, but she was drunk and I didn't know what to do.
Let the record reflect that we're putting Jessica Marks drives again on the timeline. Miss Levin, I'd like to ask you a little bit about yourself that night. You told us on direct that I remember everything that night, but that's not true, is it, Miss Levin?
Yeah, when I said that, I just meant I remember it real vividly, the parts that I do. I mean, it was 2 years ago, but those pictures, I certainly remember what happened at that table.
Well, Miss Levin, that's not quite the truth, is it? Because you actually don't remember if Jessica Marks finished any of those drinks you told us she had, do you?
I mean, I assume that she did. Like I said, it was 2 years ago. But I mean, when I say I remember, that's what I mean. I didn't want to be lying to you, so.
So to be
Sorry.
clear, Miss Levin, that's a yes to my question. You don't remember if she finished those drinks?
I'm sure she did, but I don't remember specifically, no.
You also don't remember what order those drinks came to your table in, do you?
I can give a estimate based on the pictures, and I know that the wine was first and the shots were last, and the Jack and Coke was about in the middle, but all of the seltzers and stuff like that, they just kept serving them. They were just sort of flowing through onto the table.
So that's a yes to my question. You don't remember what order the drinks came in?
Well, yeah, I guess that's a yes, except for those things that I just explained.
Ms. Levin, you also don't remember where the other customers on the rooftop were sitting that night, do you?
I'm not sure what you mean. I mean, I know there were other people up there, but I couldn't tell you their table number or anything like that.
So that's a yes to my question. You don't remember where other people were sitting at the bar you were at for 3 hours?
No, I wasn't really paying attention to other people. My best friend was in town.
Ma'am, you told us word for word what you claimed Sunny Meta said, but you don't actually remember what her voice sounds like, do you?
I mean, if I heard it today, I most definitely would. I'm, again, not sure what you mean, ma'am.
Ms. Levin, I'm asking you that you said on direct word for word what you claim Miss Sunny Meta said, but you can't tell us what her voice sounded like right now.
Again, I mean, if she were talking, I would know that it was her. And just because I don't really remember the pitch of her voice doesn't mean I don't remember those words.
Ma'am, that's a yes to my question. You can't tell us what her voice sounds like.
Yeah, that's a yes.
Ma'am, you were drinking that night too, weren't you?
Over 4, 5 hours, I had 2 glasses of wine, a beer, and a shot. Yeah.
So you're telling us right now that you drank all that?
Over close to 5 hours, yeah.
And are you telling the members of the jury today that after drinking that your memory is pinpoint of that night?
No, even without drinking that, it was 2 years ago. So I can't say it was pinpoint, but I remember the things that led to my best friend dying.
No
You
further
can't
questions,
forget
Your
something
Honor.
like that.
Thank you, Ms. Levin.
Thank you, ma'am.
Okay, thank you very much. Witness is excused. I think we are moving to the defense to call your witness. Is that correct?
Thank you.
Yes, Your Honor.
Okay.
Before we call our witness, Your Honor, we'd also like to enter a short excerpt from the Stevie Rager deposition that the opposing counsel entered before their direct examination.
Okay, let's take a look at that. What are you asking to admit?
Yes, Your Honor. For this is displayed constructively out of the view of the jurors, but we're asking to admit on this page lines 6 through 8 and lines 11 through 12.
Is there any objection from the plaintiff?
Yes, Your Honor, under the rule of completion, I just ask that the rest of that answer be, at least that I can see it. I'm not sure what it is, but if it is something objectionable, then I will retract this. But I would like to at least see the rest of this answer. That way I can determine if under the rule of completion, this would
I think that's
Your
reasonable.
Honor,
entered in as well.
apologies, Your Honor, you cut off for a second.
I just said I think it's reasonable for him to be allowed to see the rest of the questions so he can decide whether he wants to ask for that to be moved into evidence as well.
Could you just give me the page number and line, and I should be able to
Of
find
course,
it.
Your Honor. My second chair is now screen sharing the rest of that page.
Thank you. Yeah, I would say under the rule of completion, I would say that's the point of the part of the answer that actually answers the question that was asked. So I asked that that portion be admitted as well. That being lines 8 through 10.
Ms. Garcia, would you like to respond?
Your Honor, first of all, we don't believe that the rule of completion actually falls under this. The rule of completion states that an entirety of an exhibit should be entered into evidence, and the fact that opposing counsel did enter simply excerpt of this exhibit is reasonable enough for us to say that we should only be able to enter excerpts.
I would just like to make it clear, I'm not objecting to entering excerpts. I just ask that the excerpts are allowed to include context that contextualizes what is being entered.
I'm going to rule that the entire answer is going to be allowed to be admitted.
Yes, Your Honor. So just to be clear, Your Honor, and for the record, we're admitting of this page lines 8 through 10 and lines sorry, Your Honor, opposing Miss Perez, if you could just please pull up the other ones. Yes, lines 11 through 13.
Mr. McLaughlin, any objection to that part of the exhibit?
No, Your Honor.
Okay, then it'll be admitted.
Yes, Your Honor. May I proceed with my direct examination, Your Honor?
You may.
The defense calls Miss Sunny Mehta to the stand. Good morning. Could you please introduce yourself to the court?
Good morning. My name's Sunny Mehta.
Miss Mehta, what is your occupation?
Well, right now I'm looking at trying to start up another business, but I used to be a bartender.
And do you know why you're here today?
Yeah, I do. They're saying that I overserved Jessica Marks on March 24th.
I'd like to talk about that night, March 24th, 2019. Do you remember Miss Marks coming into your bar?
I do. She came in with a friend at around 9 p.m. that night.
Do you know who her friend was?
Yeah, it was Morgan Levin, the little Southern girl we heard from a bit ago.
What did Miss Levin and Miss Marks do when they entered your bar?
Well, when they entered, they were at the actual bar part of it, but they went up the stairs to the rooftop. You know, the bar was called Sunny's Rooftop Bar, so that's where they went.
Before we get further into that night, Miss Mehta, I'd like to ask you about your job. Miss Mehta, do you have any control over what someone does before they enter your bar?
No, I don't.
Miss Meta, did you know what Jessica did before coming to your bar that night?
No, I'm not sure what Miss Marks did before coming to the bar.
Did you know what she planned to do when she was coming to your bar?
No, I assume ordered some drinks, but other than that, no.
Objection, Your Honor. This
Mr.
question asks
McLaughlin?
speculation.
Your Honor,
Repeat
if I may?
repeat the question first. Ms.
Your-
Garcia?
Yes, Your Honor. Did you know what Jessica Marks planned to do before coming to your bar? And my witness answered, no, I assumed she was coming to have some drinks.
And Mr. McLaughlin, are you objecting to the question or the answer?
The question.
I'm going to overrule objection as to the question. It does not call for a speculation as to whether she knows or does not know. She knows whether she knows or doesn't know.
Thank you, Your Honor.
Yes, Your Honor. Miss Meta, were you able to finish your answer?
Yes, I was.
Miss Meta, do you have any control over what a customer does after they leave your bar?
After they leave the bar, no.
So let's talk about what you have control over then. How would you describe your job as a bar owner?
Well, I own the bar, so I got to do things like manage it, pay the bills. I also had to go through, this certification process to actually be certified to be a bar owner.
That certification process, what did that entail?
Well, just having to learn about what, obvious intoxication is, learning how to tell if somebody is, really drunk so that, when to cut them off.
You said learning what obvious intoxication is and identifying that. How do you identify that?
Well, if there's lots of different symptoms people could possibly exhibit if they're obviously intoxicated. They could have bloodshot eyes or watery eyes. Usually they have, poor motor skills. They're kind of falling around. They can't really walk very well. Or, they're talking loud or they're slurring the words, things like that.
Well, as a bar owner, have you ever seen someone who is acting like that at your bar?
Oh, of course. I mean, we see somebody who's obviously intoxicated at maybe once a week.
And what does your training call for you to do when you see someone like that?
Well, you can't serve them anymore if they're obviously intoxicated.
Ma'am, I'd like to go back to that night that Miss Marks came in. How many times did you interact with Jessica Marks?
I'd say about 8 to 10 times.
How many times did you interact with Miss Morgan Letton?
The same. They were sitting at the same table, so about 8 to 10 times.
And whenever you came to the table and saw Miss Marks, did she ever show any of those signs you just told us about?
Miss Marks
Objection,
didn't
Your Honor.
Do you
On the
object?
same grounds as during the Morgan Levin direct, I just asked that this witness once again testify as to what they claim they saw, as opposed to a general statement as to if she was showing these signs or not.
Your
Ms.
Honor.
Garcia.
Yes, Your Honor. My question began with when you came to the table and saw Miss Marks. Your Honor, we're only asking for what this witness saw and perceived by her reasonable extent of perception.
Because of a preamble to the question, I'm going to allow it.
All right.
So
Thank
Yes.
you.
I'll re-ask the question, Miss Meta. Whenever you came to Miss Marks' table and saw her, did you see her show any signs that you just told us about?
No, I didn't see any signs of obvious intoxication from Miss Marks.
I'd just like to go through a couple of those with you. Let the record reflect that we're now showing a chart that shows Jessica Marks and a few of those signs that we'll go through in just a minute. Miss Meta, did you see Miss Marks have red bloodshot eyes?
No, I didn't.
Your Honor, I object to this demonstrative. May I
on
be
the
heard?
basis of, yes, go ahead.
This is once again testimony as to what the witness saw, the signs that they specifically saw. So posing this as a blanket statement of what she exhibited the entire night by just having signs and then Jessica Marks mischaracterizes the evidence and would thus mislead the jury.
Your Honor, if I may.
Go ahead.
We believe that opposing counsel is objecting to 403 misleading. For that to be in question today, that this demonstrative has to be substantially more prejudicial than it is probative. Your Honor, we're simply using this to show the jury what Ms. Mehta is saying, and we're about to add Ms. Levin in a minute. So we're not mischaracterizing anything. As opposing counsel just stated, we're only asking and putting on the chart what Ms. Mehta saw. That's not misleading, Your Honor.
I'm going to allow the exhibit on the basis that it is understood that this is based on the framing of the questions, that this is what this witness observed. And because that goes to the heart of this case, I think it is quite relevant, and I'm going to allow it. Objection is overruled. A good objection, but I'm going to allow it.
Thank you, Your
Yes, Your Honor. Ma'am, when you saw Miss Marks, did you see her exhibit any loss of hand-eye coordination?
Not when I saw her, no.
When you saw Miss Marks, did you ever see or hear her slurring her words?
No, I did not when I saw her.
Well, then I'd like to ask you about the other person you said was with Miss Marks. When you saw Miss Levin, did she ever show any signs of intoxication?
Yeah, she did.
Well, let's go through these same signs. Did Miss Levin have red or bloodshot eyes?
Yeah, she did.
Did she ever show a loss of hand-eye coordination while you were there?
Yeah, a little bit.
Did you ever hear her slurring her words?
Oh, yeah, she tripped over her words a few times, yeah.
Let the record reflect that we've now placed 3 green check marks under Morgan Levin. Miss Mehta, I'd like to ask you about the end of the night. Do you remember when Miss Marks and Miss Levin left the bar?
I do. They left at around 11:50.
And when they left the bar, did you have any idea of how they were getting home?
Yeah, because Morgan, she didn't seem like she was doing too well. So I actually went over to their table to make sure that she wasn't driving. I asked her friend Jessica, I said, hey, this one's not driving, is she? And Jessica told me that Morgan wasn't driving and that Jessica was going to drive.
Objection, Your Honor. Hearsay.
Your Honor, if I may.
Go ahead.
Your Honor, this falls under 801D2, party opponent statement. Miss Ethel Marks is our party opponent, and she's here on behalf of her deceased daughter, Jessica Marks.
Not sure that's going to carry the day. Mr. McLaughlin, would you like to respond?
I would say that Jessica Marks is not the party opponent in this case. She's the deceased, although her mother is representing her for her death. She is not the party opponent. In this case, I guess that's how I would understand.
I'm going to agree with that. While the plaintiff's mother is here as the representative of the party opponent is not available and subject to cross-examination as she is deceased. So I don't think that's going to carry the day for you.
Yes, sir.
Would you like to be heard further on this objection?
Yes, Your Honor. We then say that this is an exception to hearsay, as it is an intention that Miss Marks planned to drive home, not Miss Levin.
Mr. McLaughlin, what do you think about that?
Your Honor, this is being asked both of what more, I'm sorry. The question was asked, do you know how they drove home? I believe, opposing counsel, correct me if I'm wrong in that memory, but I would just ask if it is for intention, the question just be rephrased as to, do you know how they planned to go home?
Your Honor, if I may be heard.
Go ahead.
Your Honor, that was my question. I asked my witness, did you know how they were planning to get home? And she told us, yes. Miss Marks told me that she was planning on driving.
I'm going to overrule the objection on the basis of hearsay as argued by both counsel, and I'm going to allow the question to answer. Go ahead.
Thank you.
Sorry, I'll allow the witness to answer. Sorry.
Yes, Your Honor. Miss Mehta, could you please restate your answer?
Oh, yeah, I was just saying that, since Morgan, she wasn't looking too good, I walked over to the table to make sure that she wasn't driving. So I asked a friend Jessica, I said, this one's not driving, is she? And she said, of course not, I'm driving home. So Jessica told me that she was going to drive the both of them home.
And Miss Mehta, at the end of the night, when you saw Miss Marks leaving your bar, Did you see her show any of the signs we talked about today?
No, she didn't seem obviously intoxicated.
And when she was leaving your bar, did you see her order an Uber?
No, I didn't see Jessica order an Uber.
When she was leaving, did you see her call a cab?
No,
When she was leaving, did you hear her change her plans to drive home at all?
no, I didn't.
Thank you, Miss Meta, for coming in today. No further questions at this time.
May I inquire?
One moment, just 1 second.
Apologies, Your Honor.
All right, counsel for the defense, plaintiff, if you'd like to cross-examine, please go ahead.
Good morning, ma'am. Before we discuss some of the claims you just made, I want to make something clear to the jury. You represent the defendant in this case, is that right?
Yeah, I'm here on behalf of Sunny's Rooftop Bar because I was the owner at that bar.
And you were the owner of that bar before it was closed, is that correct?
Yes, sir, that's correct.
And you had to close it down because your liquor license was rescinded due to this incident with Jessica Marks.
Yeah, that's true.
And you representing and being the former owner of Sunny's Rooftop Bar, this means that if the jury were to find Sunny's Rooftop Bar liable for the death of Jessica, you would be the one to suffer the losses?
Pretty sure that's what that means, yeah.
Now, let me turn your attention to the night in question. So you served Miss Marks and Miss Levin an entire bottle of wine, is that right?
I did, that's what they ordered.
As well as 3 White Claws
That's what they ordered, yeah.
and 2 beers
Again, that's what they ordered.
and green tea shots.
Yes, sir.
And you observed Miss Marks to be about 5 feet tall.
Yeah, I'd say she was about 5 feet tall, 110 pounds, but I didn't measure her or anything, so.
And your claim that you just gave in direct examination is that throughout the entire night, not a single time was Jessica Marks displaying a symptom of intoxication?
Well, I mean, you gotta understand, I only interacted with her about 8 to 10 times, so it's not like I was with her the whole night, but I did not see her exhibiting any signs of obvious intoxication.
And you've been watching this trial, is that right?
Yes, sir.
And you saw Exhibit 10, that being the video?
I have seen Exhibit 10 before.
And you're able to recognize the setting of this as being your bar.
Yes, sir.
And in this video, you would say Miss Marks was acting drunk?
No, I wouldn't say that, no.
So you're saying that during that video, she wasn't displaying any symptoms of intoxication?
I'd say that, we're talking about Exhibit 10, right? I mean, I would have been a little concerned. I probably would have kept more of an eye on her table if I had seen her acting like that.
Mhm.
But I never saw her acting like that night.
Let me remind you of the question. Are you saying that in that video, she wasn't displaying any symptoms of intoxication?
I would say that she didn't seem obviously intoxicated in that video, but that I would have kept a closer eye on her had I seen her acting like she was in the video.
And are you saying that in that video, Miss Marks wasn't slurring her words?
No, I don't think so.
And she wasn't displaying poor muscular coordination?
No, sir.
Okay. Now, you've also seen the autopsy report for Miss Marks, is that right?
I have, yeah.
So you're aware that at the time of her crash, Miss Marks's blood alcohol content was 0.16?
Yeah, I'm aware of that.
And you're aware that that's 16 times the legal limit for minors like Jessica Marks?
I think I see what you're getting at here, but the legal limit for, driving is 0.08.
One moment, Your Honor. I'm now going to be showing you what has been already admitted into evidence before this trial. It has entered in as Exhibit 22. This is the police report. I will have this up for you in one moment.
All right.
If I said 22, I believe I misspoke. It's actually Exhibit 23. Now, Ms. Marks, if you could you please read the second paragraph of the second page, starting from the last sentence in California?
The second paragraph on the
Second
second page.
And that would be the third sentence. I apologize.
Okay, I see.
In California, yes.
In California, it's illegal to drive with a BAC of 0.08 and illegal for someone younger than 21 to drive with a BAC of 0.01. It's also illegal to serve someone alcohol if they're younger than 21. Yeah, I see that, but you got to understand, I didn't know that they were younger than 21. I thought they were of the legal drinking age.
Ms. Mehta, I'll ask my question before I show this again. I understand there may be some confusion. The legal limit for Ms. Marks to drink alcohol was 0.01. She was found with a BAC of 0.016. That would make her blood alcohol content 16 times the legal limit for Ms. Marks.
Yeah, yes, I do see what you mean, but I would like to say again that I did not know that they were minors.
All right, thank you. So, Ms. Marks, you're also aware of, or I'm sorry, Ms. Mehta, you're also aware of where Ms. Marks crashed, is that correct?
Yeah. Mm-hmm.
And you would agree that it's not very far from where your bar is located?
No, it's not.
So let me just make this clear to the jury. Your story is that Jessica Marks was perfectly sober when you saw her leave the bar.
Well, I mean, I wouldn't say that she was perfectly sober. I mean, I knew she had had some alcohol, but she didn't look obviously intoxicated when I saw her.
And despite being 5 foot, about 110 pounds, your estimation, she wasn't showing any signs of intoxication anytime you saw her.
No, she wasn't. But I only saw her about 8 or 10 times that night. I had other customers at the bar.
And of those times, I'd just like to make it clear, you are claiming that she never displayed a single sign of intoxication.
No, she didn't.
Despite having a blood alcohol content 16 times the legal limit, she'd never displayed a single sign of intoxication anytime you saw her.
By the time that she had, crashed, that's what her blood alcohol content was, but not the entire night. So no, I didn't see any signs of intoxication.
And that crash may have occurred on a street that you've never seen anybody else crash on. Is that right?
Yeah, that's true.
But she never showed a single sign of intoxication anytime you saw her?
Not when I saw her, no.
All right. No further questions, Your Honor.
Okay, thank you.
Brief redirect, Your Honor.
Go ahead.
Yes, Your Honor. Ms. Mehta, when customers leave your bar, do you know exactly what their BAC is?
No, I don't know what their BAC is, no.
So when they're leaving your bar, is it your job to breathalyze them before they leave?
No, ma'am, that's not my job.
Thank you, Ms. Mehta. No further questions, Your Honor.
Okay, thank you, counsel. All right, so at this point, I think we're going to proceed to closing arguments. So we will hear closing arguments from each party. Everyone should please switch back to speaker view. Also, since both witnesses have completed their testimony, you can complete the witness portion of your ballot. Before the closing argument starts, I'm going to ask to give a couple of moments for the scorers to do that so that they can then focus on the actual closing arguments. So let's give us a couple of moments, please, before you begin. All right, if the scores are ready, I think we can proceed to the closing statements.
Your Honor, may I reserve 2 minutes for a rebuttal?
You may
Thank you. May it please the court?
proceed.
Your Honor, counsel, she saw her. She could have saved her, but instead she just kept serving her. Ladies and gentlemen of the jury, I had 4 things I had to prove to you today. Before I talk about what those 4 things are, I want to tell you about how I had to prove them to you. I had to prove these 4 things by a preponderance of the evidence. And all that means is that my case has to be slightly more convincing than the defense's case. And ladies and gentlemen of the jury, when you're reviewing the evidence, I believe you will find my case overwhelmingly more convincing. So now let me remind you specifically what those 4 things are that I had to prove to you today. Now remember, the first 2 are already stipulated. They were already agreed upon by the defense. The third, members of the jury, I ask you to use your common sense. You saw in both the autopsy and in the police report that Miss Marks had a blood alcohol content 16 times the legal limit at the time of her crash. Of course, that alcohol was a substantial and a significant factor in causing her death. So that leaves, once again, the fourth. The key question in this case, did Sunny Mehta and Frankfurt Johnson serve Jessica Marks alcohol while she was obviously intoxicated? You heard the evidence, members of the jury. The answer is clearly yes. Now, in order to make this clear, let's look at your jury instructions to see exactly what the law considers to be obvious intoxication. Included in the definition in your jury instructions are a list of symptoms that constitute obvious intoxication. Members of the jury, you just need one of these symptoms to find that she was showing obvious intoxication. And members of the jury, you heard she showed almost all of them, almost every single one. Now, we heard from Miss Levin that almost upon arrival, she smelled of alcohol. Miss Marks smelled of alcohol. She was acting loud. She was slurring her words. You heard from Miss Levin that she stumbled. She had red eyes, all of which are symptoms of obvious intoxication. You also heard that when Jessica stumbled, what did Sunny Mehta say? Whoa, Frankfurt, we might need to cut this one off. A correct observation, but she wasn't being serious when she said this. She wasn't serious about any of it. She made this joke to the bartender, and later, as testified by Stevie Rager, that deposition that you'll be able to see in your evidence today, she rolled her eyes at Jessica's intoxication. It was all a joke to her. When she saw Jessica Marks stumble, when she saw her slur her words, she could have served Jessica by cutting her off. She could have served her by calling her a cab, but instead she served up some punchlines and she kept serving more drinks. Now, of course, the defense denies these occurrences,
But I have a question for you, members of the jury. Will you believe Sonny Mehta, the defendant in this case, or will you believe Morgan Levin, Jessica's best friend, and someone who has nothing to gain from dishonesty in this case? Will you believe Sonny Mehta, the woman who tried to tell you that Jessica wasn't slurring her words in that video? Or will you believe Stevie Rager, a man who was completely unattached from this case, a regular at the bar who was there that night? Will you believe Sonny Mehta, the woman protecting her own pockets in this case? Or will you believe yourself, ladies and gentlemen of the jury, your own eyes and ears? You saw this video. You saw how Jessica acted that night, incoherent speech, loud conduct, a flushed face, all of which are listed in your jury instructions as signs of obvious intoxication. Now, Sonny Mehta and her lawyer want you to believe that what you saw was not how Jessica acted that night, that she wasn't obviously intoxicated at all in front of Sonny Mehta, not until the moment she got into her car and tragically crashed. Members of the jury, Sonny Mehta and her lawyer want you to believe her claims over your own senses, because she doesn't want you to see the truth. She saw her. She could have saved her, but instead she just kept serving her. Thank you.
Thank you, counsel.
May I proceed with closing statement, Your Honor?
You may, Ms. Garcia, go ahead.
Your Honor, opposing counsel, members of the jury, may it please the court. Jessica Marks chose before she drove. Now, the plaintiff just came up here and told you that she was obviously intoxicated, but members of the jury, you heard today that she wasn't. You heard today that she made decisions before her death that cost her her life. You heard today that she chose to drink and drive. It was her choice. And as tragic as it is, because no 19-year-old girl should have a heartbreaking death like this, no 19-year-old girl should die like this. The question today is not, should this have happened? It shouldn't have. But our job today is to figure out who is at fault. Just a minute ago, the plaintiff came up here and showed you 4 things that they had to prove. They showed you this demonstrative. They said that Jessica Marks was under 21. We agree with that, but members of the jury, that's actually not something that you need to think about today. It didn't matter if the defense knew or not that Jessica Marks was under 21. They had to prove that Sonny's Rooftop Bar was licensed to sell alcohol. We agree. That's not a disputed fact today. They had to prove that the alcohol served to Jessica Marks by Sonny's Rooftop Bar was a substantial factor in her death, but members of the jury, they failed to prove that. Because we told you today, and you heard from us, that it wasn't the alcohol served that caused Jessica Marks' death. It was her negligence. Jessica Marks made those choices. And we'll recap some moments in the trial today where that was clear. Now, they also had to prove that Jessica Marks was served alcohol when she was obviously intoxicated. But they didn't prove that today. They didn't meet their burden because obvious intoxication is only proven when the defendant served Jessica Marks alcohol. The Sonny's Rooftop Bar had to know and see that Jessica Marks was obviously intoxicated. They showed you these lines and said, consider whether she played one or more of the following symptoms, but what they left out were the words to the defendant. Because it only matters today what Sonny's Rooftop Bar and what Sonny Mehta saw. Members of the jury, today you heard from Sonny Mehta herself. She told you that she didn't see any of the signs. That it's terrible what happened to Miss Marks because it is, but you can't regulate what you can't see. The plaintiff came up here and told you she saw her, she could have saved her, but instead she kept serving her. They told you she saw her, but you heard today that she didn't actually see her. Because today their burden was Sunny Meadow seeing Jessica Marks showing signs. And Sunny Meadow didn't see any of those signs. She told you multiple times today that you just couldn't tell. But we know that Sunny Meadow is actually trained to see these things, to identify these things, and so we can trust her. Because she told you that actually the one witness that the plaintiff's case depends on was drunk that night. You heard from Miss Morgan Levin on the stand today. Miss Levin on cross-examination told you that she actually doesn't remember a lot of things. She doesn't remember what order the drinks were served in. She doesn't remember Miss Marks finishing any of those drinks. She doesn't remember what Sunny Meadow's voice sounded like. She told you word for word what she thinks she said, but she couldn't tell you what his voice sounded like. That's doubt. So ask yourself this question today, members of the jury. Can we trust Morgan Levin? Because without Miss Levin's testimony, the plaintiff can't meet their burden. But even with Miss Levin's testimony, they haven't met their burden today, because today we brought you something called an affirmative defense based on comparative negligence. What this means is that if you think that they haven't met their burden, well then, case closed, that's it, we're done. But if you do think that they've met their burden, then you've got to consider our burden. That it wasn't the borrower's responsibility and it wasn't their fault that Jessica Marks was dead. It was Jessica Marks' own negligence that resulted in her death. And we've met that burden today because you heard today that twice Jessica Marks chose to drink before she drove. The first time she did that was at her Airbnb. You heard from Miss Levin. Miss Levin told you that they drank there, that they drank. And then Jessica Marks got in her car, she took her keys out of her pocket, and she drove. Jessica Marks chose to drink before she drove to the bar. She intended to get to that bar. She intended to drink and drive back home. Members of the jury, that's not acting with reasonable care. She put her life in danger when she did that, and the life of her best friend. But she made that decision again, and it cost her her life when she did it a second time. Because you heard today that at the bar she chose to drink and drive again. As terrible as it is that it cost her her life, she chose to drink and drive. Jessica Marks ordered those drinks herself. Jessica Marks chose to drive. It's natural to look for someone to blame, but when someone who has the option of a way out, an Uber that they can call, that they can get into, who their best friend pegs them to get into, and they say no after they've drank, that's a failure to act with reasonable care. That's negligence. It's natural to look for someone to blame, and it's hard for a mother to blame her daughter, for a best friend to blame her best friend, but members of the jury, you need to determine who is truly at fault. And that decision is clear. Jessica Marks chose before she drove. Find the defendant, Sunny's Rooftop Bar, not liable for her death. Thank you.
Okay, thank you. And Mr. McLaughlin, you have 2 minutes for rebuttal.
Yes, Your Honor.
And I have a question for the timekeeper. He's reserved 2 minutes for his rebuttal, but I don't know whether he had extra time left at the end of his closing argument that he started with. Does that extra time, if he has any, get tacked onto the 2 minutes for rebuttal, or is he limited to 2 minutes for rebuttal? Okay.
Yeah.
2 minutes and 11 seconds. Thank you very much.
May it please the court?
Go ahead.
Members of the jury, the defense just got up and told you a lot about choices, what Jessica Marks chose to do. But what they neglected to tell you is the choices that Sunny's Rooftop Bar made that night. They brought up this nice graphic to tell you some choices that was made by Jessica Marks, but they refused to show you the choices made by Sunny's Rooftop Bar. They didn't want you to recognize that Sunny's Rooftop Bar chose to serve Jessica Marks while she was obviously intoxicated. Now, what are the difference between these two choices? One of these choices, made by Jessica Marks, was made by a vulnerable minor with impaired judgment due to alcohol. One was made by a bar owner. Do you see the difference? Now let's talk about that affirmative defense that they took up. When you're asked on your jury verdict form to allocate responsibility, in this case, 100% of the responsibility, in this case, falls on the defendant. Now, I have something to tell you, members of the jury. We wouldn't be here today if it weren't for some poor choices made by Jessica Marks. There is no denying that. But that isn't the issue in this case. The issue in this case is whether or not Sunny's Rooftop Bar chose to serve her while she was obviously intoxicated, which we proved to you today by a preponderance of the evidence. Now, soon Judge McDonald will instruct you to follow the law in this case. So let's take a look at the law. California law addresses this exact situation and says that any bar who serves alcohol to an obviously intoxicated minor like Jessica Marks is liable, is responsible for any harm that comes to the minor due to the alcohol. California does this because they protect vulnerable minors like Jessica, who was made vulnerable by the very alcohol that the bar served to her and continued to serve to her. Do you know who wasn't vulnerable that night? Sunny Mehta. When Sunny chose to get into the alcohol furnishing business, she took up the responsibility. Vulnerable people like Jessica Marks. The defendant failed this responsibility. They failed the law, and it killed Jessica. Now, the defense wants you to place liability on the vulnerable minor over the licensed bar, but the evidence and the law say otherwise. She saw her. The law says she should have saved her, but instead, she just kept serving her. Thank you.
Thank you, counsel. Okay, so for the scoring judges, could you please complete the ballots and then click submit? I'll ask everyone to stay on until everyone has submitted their ballots, and then we'll do some brief comments.
Our courtroom ballots are all in.
Okay, one moment for mine.
Hey, Rena,
Yes,
are you submitting a ballot?
I am. I'm just about finished. I'm just about finished with it.
Perfect. As soon as you finish that, you're welcome to start comments.
Okay, thank you.
Thank you.
Right, let me see if I made any mistakes. That's everything. I'm going to hit submit. Right. Okay, I'd like to invite the scoring attorneys to give us a couple of comments on the trial as they saw it. But before I go there, I just want to say congratulations to both of you and to the both witnesses. This was very enjoyable from my perspective. I'll give a couple of comments at the end, but let's go ahead and have our scorers come on screen and give their feedback.
And I guess I'll go first. Hi, everyone. My name is Hugo Lopez. I'll keep it short because I know you guys have a long day ahead of you guys. That was a truly enjoyable round. So congratulations to you both. I'll just start with Mr. McLaughlin. I like that you reiterated your theme and theory constantly throughout your trial presentation. You kept it kind of fresh in my mind, and it was very catchy. So at all points throughout the entire case, I kept repeating it in my mind. So great job with that. To Ms. Garcia, great job on your cross. I thought that you listened well to the witness, and when you weren't getting the responses you wanted, you repeated your question and made sure that you got out of it what you needed and what you wanted to prove your case. So that was a great job. To the witnesses, to Ms. Levin, you really did a good job of playing the grieving best friend. You sold that well, and it was very credible. And to Ms. Mehta, I thought you held up well on the cross-examination. not allowing yourself to be boxed in, and constantly repeating that, the deceased wasn't obviously intoxicated to you. So I thought you did a good job and really helped the defense case in that way. So good job to everyone, and good job in your future rounds. Thank you.
And I can go second. Jeff Blank. I've been scoring and judging these rounds in the Gladiator for probably 5 years, and coach a high school mock trial team as well. Yeah, great job. I know we're supposed to just limit this to 1 or 2 comments, given that you're not going to repeat these roles again, which is crazy. 4 different roles in 2 days. I don't know how you guys do that and keep things straight. But one thing that stood out to me in this trial, I mean, it was a great trial, very easy to follow. Everybody was the themes. I know Mr. Lopez commented on that, especially with the plaintiff's theme. But I mean, both sides really did a great job on articulating a clear, concise theme and carrying it through the opening and the closing. So it really set things up really well to understand what the evidence was supposed to show. So sometimes in openings, sit there wondering, what is your theory? What's your theme? And you kind of tied that all together, very nicely. Both sides did a really great job, of that. So keep up the great work and enjoy the rest of the weekend.
I echo that. Can you see me okay? So
Yes, we can.
I've heard this several times, and I heard some new things today. So that was pretty exciting. Well done, both of you. So the theme and story, I think, are very important, how the theme is carried forth in a story. And you guys did a great job of that. The 2 things that people always walk away with are the most intense moment. So you kind of build up for that, and the last thing that you're going to end with. So both of you did an excellent job, and I wish you all the best. Thanks.
Thank you both. Thank you to all the jurors who are submitting ballots today for the council. And my comments, I'll keep them brief. They want us to keep them brief for you, and I'm going to have a hard time with that because I got lots to say. But I congratulate you all. Excellent job. And have not judged Gladiator before, and so I was kind of intrigued to see how this was going to go, given the very different from a county competition or an Empire competition or any other. So this was very, very interesting. I enjoyed it a lot. I did read the materials ahead of time, so I'd be a little prepared. And I know that there's a lot of other things in the case that didn't come in, given your time constraints. And I think that plays a role. I think that that makes a very significant difference. It also limits you guys as to how much you can accomplish in your time. But I think you guys did an excellent job for both counsel. I will point out a couple of the big issues that I found, because they may be relevant to you going forward, even though because they're not fact specific. First of all, Ms. Garcia, you did a very good direct examination with one big problem, which was that you used a lot of leading questions at the beginning of your a whole series was done on leading questions, and so kind of give you a knock for that. But Mr. McLaughlin, you didn't object to any of those leading questions, so you need to pay attention to that. That she was actually using leading questions, and I was waiting for you to object, and you didn't object. And a couple of times I tried to give you guys hints when you made objections that you didn't necessarily get the right objection, or you kind of were using the wrong exception or something like that. My answer was, on those grounds, or I'm going to, as argued, I would either sustain or if you hear that, it means there's something you haven't zeroed in on, and try and think of what else can I say about this? Is there another objection that I could make that's a different one? Or is there another exception I could argue? So listen for that, because I did try on a few of the objections to give you those clues that there was something else you could have said and done with. And if we had the time, I could go into those in specifics, but they do want to keep it brief, and I understand that. Let's see, I did like both of the themes. I really like the plaintiff's theme, he could have saved her. That to me really stuck with me. Oh, that was powerful. That changed my kind of view on it. And the other hand, she chose before you drove. She drove. That was powerful too. And I like the fact that you focused on the fact that she went to the bar with the intention of drinking and driving. That they didn't Uber to the bar. They didn't, there were other things they could have done. When you're going out for drinking, you shouldn't be taking a vehicle with you unless you have a designated driver. And she was the designated driver because she's driving a rental car, so the other friend can't drive it. So she shouldn't have been going to a bar with the intention of drinking and driving. And that, I think, was a very strong argument for you guys. There's a very strong theme for you to carry through. With regard to plaintiff's opening and closing, in both of them, you said we have 4 things to prove today, and then you said 2 of them are stipulated, so I don't have to prove them today. So you should have used more language along there are 4 elements to this charge. I don't have to prove these 2. The autopsy proves that one. The only thing I need to prove is, and then you should have focused on that one. So that would be a little change that I would have made there. But as far as witnesses are concerned, I thought you guys both portrayed excellent witnesses. Okay, I think you carried it off very, very well. Ms. Levin, I don't see your last name on my screen, but boy, you had it in the bag for being the emotional best friend who was reliving all of this, and that was very powerful, very moving. For Ms. Defendant Maida, that you had a harder burden to carry because you got to be a little more detached. You can't get emotional about it. But you also had a harder case because it's really hard to believe that they didn't see any signs of intoxication, and then they just drove out of the driveway practically and over a cliff. So I mean, it really was a credibility thing here. Not how you portrayed the witness was a credibility issue. The witnesses, statements, the witnesses, position that, hey, I kept serving her drinks because she didn't look drunk to me at all. It's a little hard to swallow, that credibility question. It was like, if it had been more about, well, she was a little intoxicated, but she wasn't, yeah, sure, you could tell she'd had a few drinks, but she wasn't obviously intoxicated. You could have, I see people leave here all the time who've had a few drinks, but they're not obviously intoxicated. So it's a finer line for you to draw. So I'd say the credibility question there has more to do with the facts on the witness statement than how you portrayed it. But I think you had a harder job to move the juror to be sympathetic to you. So, but I thought you carried it off very well, and you did a very good job. I found you a likable witness, but I think the credibility questions for your character are really hard for you to overcome. So, but I thought you did a great job. So, anyway, that's all I'm going to say right now. Congratulations to you all. Good luck with the rest of the competition. And I wish you all the best. Thank you very much. It was very entertaining.
Thank you so much for judging, and to all of the judges, if they're still on this call, thank you so much. I mean, I'm sure as coaches or previous judges that we train really hard for this day. So it means a lot. Thank you so much.
Thank you to everyone. We really appreciate you taking your time out of this morning to just come and watch some high school kids compete in a mock trial.
Awesome. Bye, everybody.
Bye.